This virtually and not in person. I'm Kate McKinney. I am a lawyer here at Martin Pringle in the Overland Park office, and I'm going to moderate and keep an eye on the chat box here today. And Laura and Terry are going to visit with you about terminations and layoffs, a very not uplifting topic for our morning, but really important to talk through all of the potential legal issues. So Terry, I'm going to turn it over to you to introduce and get us started.
Hi, I'm Terry Mann. I am a lawyer with the Martin Pringle firm in the Wichita office. Been here 34 years and do almost exclusively employment law, mostly on the employer side. And happy to be here today to talk about a problem area for lots of employers. Laura, would you like to introduce yourself?
Sure. I wasn't sure if you wanted to just jump right in, but I'll introduce myself first before we get started. As Terry and Kate mentioned, I'm Lora Jennings Mizell. I office out of our Overland Park office, but also practice in Missouri. So I think we have some folks in the Kansas City metro area. So to the extent that we touch on anything Missouri, I can touch on that or answer those questions. But I also practice in the employment law arena, both in Kansas and in Missouri, and primarily for employer side as well.
Okay, today we're going to talk about terminations. And, you know, some people keep statistics about employment law, and it's a good thing that they do, because if you track the filings in federal court, the number of cases that get filed there, the number two on the hit parade are various kinds of employment cases. The only kinds of cases that there are more of are prisoner litigation. You know, some guy got chunky peanut butter and he wanted smooth, and so he files a lawsuit in federal court. Those lead the league, but employment matters are number two, and there are a lot of them. And nationwide, these folks who keep statistics say that if an employer is sued and they end up defending the case, if they take the case to trial, the average amount of attorney's fees that the employer will spend is approximately $250,000. And that is if you win. If you lose, then you get to spend that $250,000 for your lawyer, and you may have a judgment against you for a varying amount, and you will probably get to pay the other side's attorney's fees too. So these cases are very expensive from a money standpoint, but they're also costly in another way, and that is that while your supervisors or your HR people are sitting in our office being deposed or answering discovery, they aren't tending to your business. And so there's an intangible cost there as well. And if we can help you avoid getting into a lawsuit, we consider that a good day's work. And the times when most lawsuits arise are at termination. So it's important to consider these issues ahead of time rather than doing something on the fly that may come back to bite you later. I always tell employers that a termination should almost never be a surprise to the employee who's being terminated. There are some exceptions, you know, if somebody does something horrible and it's cause for an immediate termination, then you should do that. But if it's a performance issue or an attendance issue or an attitude issue, there should have been points along the way where the employer was counseling or warning or trying to remedy the situation with the employee and making them aware that something needs to change, or else there could be a termination. It's almost never a good thing when an employee comes in and is blindsided by the fact that they're being terminated. I get employers who say, do I have to provide employees a copy of their personnel file? And I always say, in Kansas, the personnel file belongs to the employer. And no, you don't have to give them a copy of your personnel file, short of getting a subpoena or a court order for it. But there shouldn't be anything in the file that comes as a big surprise to the employee. If they got a bad review or somebody complained about them, that's something they should have been made aware of earlier on. So try to avoid surprise terminations. And if you have a policy, lots of employers have a progressive discipline policy that calls for various kinds of discipline. You know, first you'll give a verbal counseling and then a written warning and then a suspension. If you have a policy, you don't have to, but if you do, be sure you're following it when you get to the termination. Because when you're sitting up at the federal courthouse and the jury's looking out of the box at you, it's almost a given that everybody on that jury is an employee, and very few of them are employers. You almost never get someone who's a manager or a supervisor or a company owner sitting on a jury. They're mostly employees, and if they bring any bias to the process, it's going to be that they look at things from the standpoint of an employee rather than an employer. Now, if you analyze your termination process, one thing you need to do is to be sure that the termination is not occurring for an improper reason. And there are lots of things that are improper reasons. As all of you know, it's contrary to a lot of different federal laws to terminate someone because of their membership in a protected group, such as age or race or sex or disability or religion or ethnic background, or there's lots and lots of things that are a protected category. And if that is the reason, then you're off on the wrong foot and you shouldn't be doing that. That doesn't mean that people who have membership in a protected group are immune from termination. They are not. It just cannot be the reason for your adverse employment action. It is also against the law to terminate someone for participation in protected activity. And all of these statutes that apply to employers have a non-retaliation provision. If someone comes to HR and says, I have a complaint, I believe I've been discriminated against on the basis of my gender, they don't have to be right. If they have a good faith belief when they come in and make that complaint, that's enough. And you cannot terminate them for making the complaint, even if you conclude that their reason was wrong. Even if you think there isn't any discrimination on the basis of gender, they're still entitled to make that complaint and to be protected. And we have some new categories of protected activity. If someone is seeking or using leave under the FFCRA, the new federal statute that provides for paid sick leave and paid FMLA leave for COVID-related reasons, that is also protected activity, even if they're wrong. I have an employer who's not covered by that statute because they're a healthcare provider. But if one of their employees comes in and says, I'd like to have leave under the FFCRA, I've been looking on the internet and I've figured out that I think I'm entitled to leave, you can't punish them for suggesting that, even if they're not correct. And so be sure that there isn't any retaliatory reason for the termination. Some other categories that are protected and should not form the basis for a termination is if an employee has a work injury or a work comp claim, that's protected. There's even a Kansas case where an employee and her mother worked for the same employer, and the employee had a work comp claim, and they fired mom. And she alleged it was because daughter had a work comp claim, and the court said there's enough there that we're going to take that case to trial. So watch out for those kind of wrinkly issues there where somebody has a work comp claim or even just an injury that they've told the employer about. Those are the kinds of terminations that are risky. And when you call Lora or me and we hope that you'll call us before you've terminated, because that gives us a chance to work through it with you. One of the things that we will always ask is, okay, let's talk about what protected categories this employee may be a member of. Are they protected due to age or race or sex or disability, or have they requested an accommodation? Have they had a work comp claim? And we're going to run through those with you so that you can think about and analyze. Because most of the time when a supervisor comes to HR and says, gee, I really like to terminate this person, they're not going to come out and say, I need to get rid of her because she's pregnant. They'll find some other reason. But the folks who are running the company and who are running human resources need to be able to ask the right questions to ascertain whether or not there's a hidden motive there that needs to be taken into account. Another problem that we see sometimes related to termination is documentation. And I had a trial one time, and one of the members of the jury who we got to talk to afterward said that she really appreciated the fact that the documentation was so thorough, because she said she works for the Bureau of Prisons, and their saying is that if it isn't documented, it didn't happen. And that's the way a lot of jurors look at it. They're expecting employers to have thorough and complete and contemporaneous documents. And so if you're saying, I need to terminate this person because they're a poor performer, then before you make that decision, you need to look at their performance reviews. And one of the hardest cases to try is when you say this employee was terminated for poor performance, but when you look at their performance reviews, they're glowing. Lots of supervisors don't like to give those difficult reviews where they crack down on somebody's poor performance, and so they will gloss over it and give a review that suggests that the employee is performing as expected. But if that's your documentation, then you're going to get beat about the head and shoulders with it when you go to court and say this employee was fired for poor performance. Your documentation has to match up with what your explanation is. In all of these cases, you know, the burden of proof is on the employee to say, I believe I was terminated because of my age. And then the employer has to come in and explain why the termination took place. And then the employee has to overcome that with proof that there was pretext. And one of the ways that employees can prove pretext is if the employer's story doesn't match up, if the documents are different from what the testimony is at deposition or trial. And if you have a documentation problem, the time to take care of that is before you ever make the termination decision. Sometimes employers are very tidy and they want to get rid of documentation pertaining to employees who've left the job. But you should be aware that there is a statute of limitations, and the longest statute of limitations in Kansas is 5 years. And so I generally recommend that if someone leaves your employment, it's a good idea to hang on to their personnel file for that long in case something comes up. The statute of limitations for a discrimination claim is much shorter. They have 6 months to file with the Kansas Human Rights Commission and 300 days to file with the Equal Employment Opportunity Commission. So you'll know about those claims sooner, but don't ditch your file too soon. Another thing you need to think about regarding termination is just the procedure. You know, what day of the week is it going to happen? Where is it going to happen? Who's going to be there? And if you read enough cases, you get the sense that lots of times employees file a lawsuit because of the way they were terminated. If they felt like they were treated disrespectfully or with a lack of consideration, sometimes their response is to strike out against the employer. So, for example, there was a case where it was Bring Your Daughter to Work Day, back when it was just daughters, and the guy had brought his daughter to work. She's 8 years old. She's going around with him in the workplace, and that's the day the employer decided to fire him. And so while his daughter was sitting outside HR waiting for him, Dad was in the HR manager's office getting terminated. That's not a good plan. It's not a good plan to terminate an older employee on their birthday. I've known that to happen. Don't do that. Think about when it's going to take place. It's generally a good idea to have a witness present with you, so that you don't get into a contest of he said, she said, or she said, she said. Have somebody there who can verify what was said and what was done. You need to think about where it takes place. It needs to be in a private location, not out on the shop floor where everybody can see and hear what's going on. You need to think about in advance whether you need security, either for your computer system or personally, and make sure that that's available. You need to decide in advance whether or not you are going to contest a claim for unemployment. I've always said that in Kansas anyway, the test for getting unemployment is if you ever had a job and now you don't, then you get unemployment. But it's gotten even more pronounced with COVID. So think about that and give that some thought. Make a decision before then. And sometimes it's helpful to be able to tell an employee, if you're letting them go, look, we're not going to contest it if you file an application for unemployment. You do need to make sure that you're not setting yourself up for a sabotage situation by cutting off computer access or access to the building after the employee is terminated. All of you are aware, I'm sure, that employees sometimes don't take this news well, and you don't want to get into a workplace violence situation by permitting someone who shouldn't have access to your premises to continue to. So think about getting back keys or employee swipe cards or credit cards or whatever the employee has that you need to have back. But those are some considerations that you need to have top of mind when you think through a termination and plan it out in advance. Laura, anything to add to that?
I don't know that I can add anything.
I've got a quick question for you, Terry. Especially on I think the first two topics that you were talking about with regard to considering protected class and documentation. How do those figure in if your termination is based, as many employers' terminations are based in the current situation, on just economic reasons? I've got to let some people go because I can't afford them, and so I'm picking these three. How does that change your analysis, if at all?
Right. It's an important process to think through, and generally what happens if you're doing a reduction in force, say, think about the snapshot of your workforce prior to the reduction in force and after. And if the average age of your workforce before the reduction in force was 55, and after the reduction in force it's 30, then the plaintiff's lawyers will hire a statistical expert to come in and testify that the reduction in force had a disproportionate impact on people in the protected age group, or people who are female, or people who are disabled. There's been litigation right here in Kansas that an employer conducted a reduction in force with a specific purpose of eliminating people who had health insurance claims or some kind of disability. And so in vetting that termination, you need to be sure that there isn't a disproportionate impact on folks in the protected age group. And there's lots of reasons to make a reduction in force for economic reasons, but you need to sit back and look at it from the perspective of the plaintiff's lawyer. Is the documentation going to demonstrate a disproportionate impact?
Thanks. Sorry, I didn't mean to interrupt you, Laura.
Oh, good question.
No, that's I can't think of anything that I would add to your list, Terry. I think I'm trying to think of some tight spots that some of my clients have got themselves into, and I think I just think from where Terry and I sit, we look at these things through the eye of a plaintiff's attorney, and because it's you all know the history of your employee, you know their performance, you know their mannerisms, you know if they've been a good employee or if they've been difficult, if they have performance issues, and those may all well be documented. But the challenge is there what are we not thinking of at the time of this termination? Has the employee ever made a complaint to somebody? It may not be you, the person sitting there meeting with the owners or meeting with HR or the HR department or whomever, but perhaps that person has made complaints or statements to other employees that are well known. And so Terry and I sit here and try to think of anything that might come up when this person who will become a former employee seeks their own counsel and says, they say that my termination is because of my performance, but I really truly believe it's because I participated in this investigation of a complaint about another employee who made a complaint about another employee's fill in the blank, that they engaged in some other protected activity, that they made a complaint, that they had expressed some concern, something like that. And so I think it's the taking the time to plan these out. As Terry said, there should not be a surprise termination, and that's a good rule to live by. And if you do that, then you will give yourself enough time to call counsel, get your documents together, review them, make sure they say what you think they say, and then fly spec any potential other issues that might be out there with the employee that we're not thinking of, that they might come back with.
So, Laura, Terry mentioned being aware of retaliation related to FFCRA inquiries. Are there other COVID-related areas that employers should be thinking about with regard to terminations? I think you and I had previously talked about, or you had mentioned previously, some OSHA and workplace safety types things, but are there that and then anything else COVID related that employers should be looking at when they're thinking through terminations?
Yes. So the way I was going to kind of come at this for purposes of our discussion is Terry has done a great job of kind of laying the groundwork of how to approach a termination. And if we sit here now and say, all right, we are now almost November into the year, depending on your location, businesses are not sure how things are going to go as far as COVID is going to be impacting them. Retail is probably going to be impacted in some way. Waiting to see how that works. And so COVID continues to be a factor in business decisions. And if it impacts, a business's bottom line, its customers or its revenue activity, then the business has to look at other expenses. And so one of the things that attorneys across the country are seeing is that the way that certain fact patterns relating to COVID are playing into terminations, layoffs, reductions in force, and how those claims are coming up in the courts. And these are meant to alert you again to kind of that issue spotting. That's what is so critical here, is to take the time or give yourself as much time as you can to do these types of issue spotting. One potential claim may be that an employee believes that the employer is not providing a safe work environment, and that there should be more protocols, there should be different policies and procedures, there should be other or more protective equipment. People in the Kansas City metro area, and I'm sure in Wichita as well, one example of this are some of the frontline healthcare workers at some of the hospitals there will be media coverage that they have organized protests to alert the media or others in the community that the healthcare workers believe that certain hospitals are not providing enough PPE. One way an employee can pursue that belief is to contact OSHA and make a formal complaint to OSHA to say that this company is not meeting its federally mandated obligation to provide a safe work environment, which employers are under OSHA. And once that complaint is made, then now that person has engaged in what Terry was talking about in that protected activity. And so the employer may find that it is contacted by OSHA, and that's its own separate process. And then if the person is later terminated, even if for unrelated reasons, I think you can and should plan that the employee will maintain that the termination was not because of some unrelated performance reason. It was because of their decision and engagement in that protected activity of making that complaint. So that is, again, one example. A similar example is if employees believe that there have been other safety violations. Certain regulated employers, if they believe that the employer has again not offered a safe work environment or has violated safety protocols, another government agency that will field that type of complaint is the National Labor Relations Board. And as a reminder, that agency we typically associate with union activity, which is true, but that agency has jurisdiction, so to speak, over both unionized and non-union employers. So that's something to keep aware of, that those folks may respond to a charge and come and have an investigation to see how the business is operating. As Terry mentioned, again, in our prior webinars, we've talked about the new bases for leave. If someone has COVID or been exposed to COVID, they need leave. Those types of paid sick leave issues, FMLA, Emergency Family Medical Leave Act, and some of the ADA issues that may raise as well. So if someone has COVID or believes they have COVID, that should be a big alert to you before any quick or dramatic action is taken with respect to employment. Be sure you consider all of those angles. The other way some of these claims are coming up is, and we saw these actually at the beginning, and I think Terry saw them, and I know I did. We had employers who would contact us to say, I have employees who are saying they don't feel safe to come to work. And they are either in a high risk group or have something going on at home that they don't believe that they can come to work, or they don't believe, again, that there's enough protective equipment that would make them feel safe coming to work. That's another iteration of what I've talked about. So if you hear an employee come forward with that type of concern, complaint, statement, whatever it is, be sure you fully respond to that and make sure you engage with that employee before making any adverse employment actions. Another claim that I was reading about is an employee has claimed that they requested to be allowed to work remotely and that request was denied. The employee then filed a wrongful termination claim on the basis that the refusal to allow her to work remotely was a violation of the state's policy based on some of the quarantine orders, ordinances, and those types of things. And I use that term broadly, but I think everybody knows what I mean, is if the county or the state has issued some sort of order or ordinance that has closed businesses or some kind of impact on how the business can be operated and where employees can and cannot be, then those types of claims are coming up as well. So to Kate's question, those are some examples of some of the types of claims that we may see more of as time goes on, and as businesses head into the winter, we're not sure, particularly for retail and some of those that are directly affected, as cases maintain or increase, and as local governments and state governments respond. We're not sure how they're going to respond, but if your employees start to become increasingly concerned about being in the workplace or prefer to work remotely, these are some of the ways that we're seeing some of those claims come up. Issues with your plans for returning to work. A lot of employers, I think, have kind of made the decision, at least the ones that sent people home, I think a lot of them said, well, at least we're going to get through this year, through 2020. We'll pick up again and revisit this issue at the beginning of 2021. If that's you, now it probably is the time that discussion is being revisited. What is our plan for remote workers going into 2021? And anytime you make changes with how employees report to work or work remotely, those have got to be negotiated and discussed and fully vetted so that you involve the employees and that there's, again, no surprises, no sudden changes that might cause people some unnecessary discomfort.
And the EEOC has issued some guidance, regarding the employee who comes in and either wants to work from home or be allowed to stay home on leave beyond what the FFCRA would require. The EEOC says the employer should address those like they would an ADA accommodation request. And as you know, that means that you have to have a dialogue with the employee. Okay, what is it that you want? You're scared to come to work, and we've told you all the things we're doing to have a safe workplace, but you want to work from home. And then the employer has to determine whether or not they can reasonably accommodate that kind of request. And so there's a process there that you can't just blow by, and you need to be documenting how you came to the decision that you can or cannot accommodate that request. And as Lora said, employers are getting all kinds of requests I had one who an employee asked for an easier job at the same pay, of course, because she was so stressed out by COVID that the burden of doing her regular job was causing her anxiety. And so the employer had to analyze whether or not they had another job that she was qualified to do by training and experience, and whether or not it was reasonable to move her to a different job because of her anxiety. So, and it was like an ADA request.
I would mention that this is counterintuitive, but I think, Terry, you've seen the EEOC guidance that also says you should not assume, and nor should you treat certain individuals as at risk, and therefore require them to stay remote. So that there may still be some thinking out there to say, well, gosh, we want to be sure to protect our employees, particularly individuals who are in any at-risk categories, who may be older or pregnant, and therefore we're going to have them stay remote. But that can run afoul of EEOC and the discrimination statutes as well. So it seems counterintuitive, but you can't protect people. It's in that way.
Kind of thread that needle.
Yeah.
So as long as we're on COVID topics, and it looks like cases are bumping up, and the economic impact seems to be kind of settling out. We're seeing headlines about waves of bankruptcies. Can you all talk about the WARN Act and what that means and who it applies to, and everything that goes along with layoffs?
Sure. The WARN Act, WARN, stands for Worker Adjustment and Retraining Notification Act, and this is a federal statute. There are states that have their own mini WARN Act. Kansas is not one of those, but there are states that do. But I'm going to talk primarily about the federal act. It applies to employers who have 100 or more employees. So if you're in that category and you're thinking about doing layoffs, you need to be aware of the requirements of WARN. Basically, WARN requires the employer to give a 60-day written notice in advance of two things, either a plant closing, which we'll talk about, or a mass layoff. And if you're going to do either one of those things, then you have to give written notice to employees and certain other administrative notices that we're going to talk about 60 days in advance. A plant closing is defined by the statute as being a layoff that affects 50 or more employees at a single site. So if you have a facility in Wichita and you're going to do a layoff that affects 60 employees, and your main business is in Kansas City, but at least 50 employees at a single site are affected, that is a plant closing. And so you need to give the 60-day written notice. The WARN Act is also triggered if an employer does a mass layoff. And a mass layoff comes in two parts. The first is if you lay off 500 or more employees at a single site in a 30-day period, or number two, if you lay off somewhere between 50 and 499 employees, if the number that are affected constitutes at least 33% of your workforce. So this is a statute that requires some mathematical calculation to figure out where you are. And it has a 90-day look back period. It's basically concerned with what layoffs happen in a 30-day period. But if you do a series of smaller layoffs over a 90-day period, and it's sufficient to make you hit one of the WARN numbers, then that's also going to trigger your responsibilities under the Act. Now, who gets notice under WARN? First of all, employees. The full-time employees that you have are entitled to a 60-day advance written notice of when their job is going to end. Now, it's a little known process that you do have to give the 60-day notice, but you don't actually have to have those employees working. So you can say today, okay, your employment is going to end on December 27th, 60 days away. However, in lieu of that, we're just going to pay you for 60 days. You can go home today. And sometimes employers choose to do that payment in lieu of notice. Say, okay, I'm giving you your notice on October 27th. Today's your last day at work, but you will be paid on our regularly scheduled pay days over the next 60 days. It's called pay in lieu of notice. And that's not a procedure that's actually reflected in the statute or in the regulations, but the damages that are available under the WARN Act, if an employer violates it, are the employees get 60 days of pay. And so if you are already paying them the 60 days of pay that you would have to do, then you've eliminated their claim for damages. So that's an option. Sometimes employers choose to do that because they're concerned about things like employees getting a work comp claim during their 60 days when they know their job is going to be ending, or employees making some other kind of claim against the employer. And it really comes down to your workforce, and if you think that's a risk, then that might be an option for you to consider. You also have to give an administrative notice to the state dislocated workers unit. And if you look in Kansas at the Department of Labor website, it identifies who that person is. And I'm sure Missouri probably does the same. They have to get the written advance notice also. And you have to give written notice to the local chief elected official in your area, which is normally the mayor. You have to go give a letter to the mayor saying ABC company is notifying employees that they are going to be laid off in 60 days. And you have to tell the elected local officials there. Some other things that might trigger WARN is that if you do a temporary layoff, you think you're laying people off because of financial considerations or things that are particularly a problem with the COVID situation, and you intend for it to be temporary, but it goes on for 6 months, then that can trigger the WARN Act. Also, if you reduce the number of hours that employees are working by 50% or more for at least 6 months, times 50 employees, then that triggers WARN. So if you're doing a temporary layoff, you need to be aware of those numbers, because that can get you into the WARN situation. Now, there are some exceptions to the WARN statute that seem to be particularly coming up in the COVID situation. One is the faltering company exception. If the employer company is out there seeking business or seeking financing, and they have a good faith belief that giving notice to everybody they're going to lay off all their employees would preclude them from obtaining that financial backing or that business, then they may qualify for an exception to the WARN Act. Now, I should say that like all employment-related statutes, these are intended to benefit the employees, and so the burden of proving that you fall under one of these exceptions is pretty high, and it's up to the employer to prove that they had that good faith belief. Another exception is unforeseeable business circumstances. If something sudden and dramatic and totally unanticipated happens, then you may have an exception to the WARN requirements. And the example that's given in the regulations is if a company's principal client cancels all their orders without any warning, then that might be a situation where you would not have to give the 60 days written notice. The statute does say that even in those situations, if you aren't able to give 60 days, the employer is required to give as much written notice as they can before they lay off their employees. The penalties, as I said, if you fail to give your employees 60 days written notice when you should have, then they are entitled to that amount of pay. There's also a penalty of $500 per day for each day you didn't give notice to the other administrative folks that are required to be notified, like the displaced workers unit and the mayor or highest elected official. So it's very important if you do that, that you make sure you give everybody the right notice. There are some exceptions. If you have a unionized workforce where the layoff process is one where an employee who is more senior can bump out an employee who has less seniority. And so you're not actually sure until that bumping process takes place who's going to go out the door, that you can give a revised kind of notice to your employees. So that might apply in a unionized workforce. Again, watch out for the state mini WARN acts. They're all over the place and very different. Kansas doesn't have one. California, of course, has one that's very onerous. Connecticut has one that says, in addition to complying with the federal act, you also have to pay your employees health insurance for 4 months. And so, there are all kinds of strange requirements depending on what state it's in. So if you're in a multi-state employer group, that may be something that you need to think about. Anybody have questions about WARN?
All right, it is 11:50. I know, Laura, you might have another quick topic that you were going to discuss.
Yeah, I'll just touch on a couple just because we told you that we would touch on these. So one alternative to a reduction in force coming off of the WARN, if that is looking like something that the company needs to reduce its hours, certainly look at the WARN Act. It depends upon how much of a reduction you need in the amount of work that the company has and the number of hours that you're going to be reducing. Another option that we wanted to mention is, so that people are aware, is Kansas and Missouri both have what they call a shared work program. And that information you can find on both states, Kansas and Missouri's labor departments. But it basically is kind of another way of allowing the company to reduce the number of hours being worked without laying people off, and allows the employees to also be eligible and entitled to some unemployment benefits. And so each one of those you need to look at, both with WARN and with this. You've got to get out your mathematical calculations and figure out just how much of a reduction in the work hours you're talking about, because each one is different. But the shared work program is by at least 20% reduction, but no more than 40%. And so you have to look at that, and you got to identify the people that would be eligible to participate in that, and you put together your plan, and then that is submitted to the state and has to be approved by the state, and then you can roll that out. So if we're talking to anybody here today that is looking at some uncertainty, rolling into colder months, into the spring, or on an ongoing basis, be aware that that is perhaps one option available to you. I think the other thing that we told you we would mention, and I think it's only worth just a mention in terms of terminations and layoffs, reductions in force. If your company received a PPP loan, out of abundance of caution, at this date and time, I think by now, most companies have been, if they did receive the loan, that loan has been funded, it's been received, and it's been processed and hopefully used by the business. And at this point now, companies are submitting their applications for forgiveness. So out of abundance of caution, it's probably still a good idea, if you are planning any terminations, just check in with the owners or the finance person in your office, or whomever, or CFO, or whomever's been tasked with handling the PPP loan, to make sure that any reduction in your workforce or number of employees or any terminations would not impact the loan being forgiven. So, back at the beginning, I think everybody was aware when those loans were being funded, you had to maintain, the average number of employees. Otherwise, the more you reduce your employment level, there would be a proportionate reduction in the amount of forgiveness of the loan. I think most people have, progressed beyond what's called the covered period in which you need to use those funds. But to again, out of abundance of caution, just make sure that any termination will not affect the forgiveness or your application for forgiveness.
I see we have a really good question about severance agreements, whether that can play into a situation, particularly in a reduction in force. And that's a very good question. Severance agreements are a little bit different in the context of a reduction in force. If you terminate a single employee and you'd like to resolve any outstanding issues through a separation agreement that has them waive their claims, if they're over age 40, then you have to give them 21 days to think about it and 7 days to renege under the Older Workers Benefit Protection Act. But if it's a reduction in force or a layoff that's larger than that single employee, then the timelines change and you have to give them 45 days to think about it and then 7 days to renege. And you also have to provide them with information as to who was considered for the reduction in force and who was not considered by job title and age. And you have to identify very carefully what your decisional unit is. For example, there's a 10th Circuit case involving Weyerhaeuser, where Weyerhaeuser was laying off a bunch of people, and they notified everybody that they wanted to sign a severance agreement, that the decisional unit was all of the salaried employees at X location. But in fact, when they got around to doing the layoff, it was salaried employees who reported to this one supervisor. And so the employees signed the severance agreements and took the money, and then they ended up challenging it later on. And the 10th Circuit Court of Appeals said those severance agreements were invalid because they improperly identified the decisional unit. Instead of saying it was all salaried employees, they should have said it's the salaried employees who report to Bill Smith. And so the courts are interpreting this in a pretty technical way. For example, you have to give the employee's title and age. And there was one employer who, when they drew up their table of who got the severance agreement and who didn't, they put the title and the employee's date of birth instead of their current age. And the court said, oh, sorry, that's an invalid separation agreement and we're voiding those because you put date of birth instead of age. And so it's a situation where the employer has to be very careful in defining the decisional unit and conveying the right information to the employee so they can decide whether they want to waive all their potential claims against the company, including age discrimination. But yeah, a severance agreement can be a good way of tying down any loose ends and making sure you don't end up in a huge bit of litigation.
All right, we are about at the end of our hour. Terry, Laura, do you guys have any last remarks before we close out?
It's always a good idea to bounce these things off of your counsel, either us or somebody else, before you make a decision that could result in litigation, because the best lawsuit is no lawsuit, except for us. We like them, but for employers, you want to avoid them.
I would agree with that. I think one of the themes you probably heard today is, as Terry said, talk with somebody about it first. And particularly now, I think jurors will hold employers to kind of a higher level of patience, empathy, and understanding. And so I think you will have to be prepared to have those ongoing discussions with employees, and that if something were to turn into a lawsuit, you know, you want to put yourself in the best position possible to show that you did empathize with the person, you heard them out, considered the entire situation, and really gave it your full attention. And so that would be, you know, as you all are dealing it with day to day, before you get to the point of needing to make the call to counsel, just continue to really give yourselves the time and give the effort and a full response with and engagement with your employees.
All right, well, thanks everybody. I'm going to end the meeting here in a second, but I will make sure that we get the video replay posted to our website here later this afternoon, and then we will email that out to everyone who is attending, along with probably some handy links to a few things, probably to the Kansas and Missouri Shared Work Program information or website pages, and maybe a few others that have been posted here. And as always, if you've got any questions related to this or any other employment related legal needs, let us know. We'd be happy to help. Thanks, everybody.
Good day.
Thanks all.